Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral argument in file number 2026-0075, TD et al. And Dr. Luis Casas versus Drew Wrigley and others. And sitting this afternoon, we have Justices Jared Tufte, Justice Douglas Barr. Justice Mark Freese is disqualified, and sitting in his place is District Judge Michael Hurley, and we welcome him to the bench. Absent this afternoon is Justice John Jensen, but he will participate in the decision by the record and reviewing the briefs and the oral argument this afternoon. Arguing this afternoon for the appellant, I have down that it's Tanya Pellegrini is the arguing, and Christina Sambor and Jess Braverman are appearing. Is that correct? All right, and for the appellee, arguing this afternoon, Mr. Philip Axt, and appearing Daniel Gosted and Joseph Quinn. Is that correct?
Yes, ma'am.
All right. Ms. Pellegrini, you may proceed.
Good afternoon, Madam Chief Justice, and may it please the Court. My name is Tanya Pellegrini, and I'm an attorney with the Lawyering Project, and together with Gender Justice and Christina Sambor, we represent the appellant, Dr. Luis Casas. At its core, this case is about whether the fundamental right to self-preservation and the right to provide and access life and health-preserving medical care, and whether the North Dakota Constitution allows the state to limit who can access medically necessary care in North Dakota. This case concerns a law that targets a very small number of North Dakota adolescents and their families, and it imposes an extraordinary burden on them. It categorically denies them medical care that the undisputed evidence at trial showed may be necessary to preserve their health and, in some cases, their lives. Not only is it completely unprecedented for the state to single out a population from being able to receive medical care, categorically ban their medical treatment, and override parental consent, but such a restriction on a deeply rooted and alienable right can only be allowed if it can pass the strictest constitutional scrutiny. And because the district court erred in applying rational basis, this court must remand for review under the proper standard.
Ms. Pellegrini, I'm sorry to interrupt you right off the bat, but you triggered an important phrase, a deeply rooted right. Would you go on to explain why this is a deeply rooted right?
Yes, Your Honor. So under Article 1, Section 1 of the North Dakota Constitution, the Article 1 guarantees that all individuals are by nature equally free and independent and have certain inalienable rights. And among those are enjoying and defending life and liberty. And that right to life and safety is one of the most comprehensive rights found in the Constitution, and it's deeply rooted in the history and tradition of North Dakota. North Dakota, we had evidence at trial that was unrebutted, that in North Dakota at the time of the founding, that the medical profession, physicians in general, were giving much deference. They were at the cutting edge of medical technology, and the state did not regulate the state did not ban them from practicing medicine like they're doing here. The one exception would be abortion, but even that has a life and health exception to it. And so this is a right that is deeply rooted and that is consistent with the history and tradition of how physicians have been given deference in this country or in this state.
Ms. Pellegrini, you said this is unprecedented. A few years back, the state passed a statute that only related to care for female minors. It's often referred to as the female genital mutilation statute. So isn't that somewhat similar to this? Limited medical care to minors, and in that case, only to females.
So I think there's a few differences. And again, that law itself might be subject to strict scrutiny as well, as it is limiting access to medical care. But here, the trial record is clear that gender-affirming medical care for some minors is life and health preserving. And even the state's expert conceded that for some minors, that is the only treatment that can alleviate significant clinical distress in some minors with gender dysphoria. And so this law should be subject to strict scrutiny because it is infringing on that.
Did the district court make a finding that this was necessary to maintain life?
The district court did not, Your Honor, but I believe that that was an error as well, as the record evidence is undisputed that for some young people, it is necessary to preserve their health and their life.
So appellants are challenging that factual finding?
With this, yes.
The lack of factual finding?
Yes, it is de novo review for the case, Your Honor.
Well, wait, you're saying it's de novo review, but that's of legal issues, not factual issues. We don't decide the factual record. The district court did that.
Yes, Your Honor, but I believe that the district court, the record from the district court is clear that this is life and health preserving care for some individuals.
But to be clear, so you're arguing it's clearly erroneous, the court's lack of factual finding?
Yes, Your Honor. This court is being asked to consider whether prohibiting licensed physicians like Dr. Casas from providing health and life-preserving medical care to his transgender adolescent patients infringes on their fundamental right. And to do that, it's helpful to have a little bit of background on how this care was provided in North Dakota before the ban prescribed it. Before the ban went into effect, there were only 2 pediatric endocrinologists in the entire state. And consistent with best medical practices, they worked together and in collaboration with a multidisciplinary care team. And Dr. Casas and the multidisciplinary care team followed medical guidelines that are evidence-based and supported by every major medical association in the country, including the American Academy of Pediatrics and the American Medical Association, who together with almost 20 other medical associations submitted an amicus brief confirming their support for the use of gender-affirming medications for the treatment of gender dysphoria, because the treatment is grounded in science and designed to improve health outcomes and alleviate suffering. These medications include puberty blockers that at the outset of puberty give young people and their families time to have these important, private, and deeply personal discussions together at their dinner tables and in the privacy of their own homes. For some older adolescents, estrogen and testosterone medications may be medically indicated for treating their symptoms of gender dysphoria. Gender-affirming surgeries were not provided to minors in North Dakota. Prior to the healthcare ban, only minors with a diagnosis of gender dysphoria and who had clinically significant distress or impairment in school, social, occupational, or other important areas of functioning were eligible to receive gender-affirming medications. And providers in North Dakota were not providing these medications to any prepubescent minors. Gender-affirming medication was only provided to adolescents who had begun puberty and started developing secondary sex characteristics, which is the cause of their distress. And parents and guardians were heavily involved in the treatment plan, and they were considered an essential part of the care team. Gender-affirming medication was only provided with the informed and thorough written consent of a parent or guardian. At trial, the undisputed evidence confirmed that no minor has been harmed by gender-affirming medication. No minor in North Dakota presented to the emergency department due to complications from receiving gender-affirming medication. No minor in North Dakota has expressed regret about having received gender-affirming medication, and Dr. Casas has never been disciplined, investigated, or received any complaints from his patients or their families related to the provision of gender-affirming care. To the contrary, the unrebutted trial record confirmed that North Dakotan transgender young people and their families who received gender-affirming medication prior to the ban immensely benefited from the treatment. The healthcare ban is a criminal law, and it contains no exceptions for when administering these medications are for the purpose of providing life or health-preserving medical care. And it provides no exception that allows physicians to exercise their good faith medical judgment and provide individualized treatment to their transgender patients. The law is completely unprecedented intrusion into the practice of medicine, and and banning this life and health preserving care has forced families and medical providers to leave the state, families to drive out of state to Minnesota to receive this essential care, and at least one young person has tried to take their own life because of the healthcare ban, and that young person ended up in multi-organ failure and was hospitalized for months.
Ms. Pellegrini, I'm going to take you off where you're going. I just want to, we have a single appellant here because everyone else was dismissed. So can you identify from your client's position, what is the facial and what is the as-applied challenge? Because the review is different.
Yes, Your Honor. So under North Dakota law, we start with as applied and then go to...
If both are legitimately brought, but
Yes.
how is this, to what extent are the challenges as applied?
So they are connected in that the group who's being impacted, and that comes from the U.S. Supreme Court, we're looking at who is the restriction impacting, not who are outside of the coverage of it. And that group is minors in North Dakota who have had a diagnosis of gender dysphoria. It's a very small group of young people, like 20 or so. It's very small. And so as applied to them, we believe it is unconstitutional. But because there are no others outside of that group that it applies to, the whole law itself should be unconstitutional on its face.
I guess my question is, none of them are plaintiffs, and I know your clients representing them or doing this on their behalf, but we have no specific facts regarding any of them. So is it really a facial challenge instead of as applied?
So there are facts about individual patients that Dr. Casas has treated. We did have initially 3 sets of family plaintiffs who are Dr. Casas's patients that testified about how they received care in North Dakota prior to the ban, that they have to travel to Minnesota for their care. So we do have facts about individual
But they were all
patients.
dismissed because the statute doesn't apply to them, as I recall.
They fall under the legacy clause exception, yes.
So then again, for specific facts on the as applied, what facts do we apply that's not just general to everybody?
So Dr. Casas did testify about specific patients that travel to Minnesota to see him that do not qualify under the legacy clause, and he did testify about their treatment as well. So we do have testimony and evidence in the record about individuals that would fall into the as-applied category. So with that context, I'll turn back to the legal argument. And so one important thing I would like to note is that the state tries to frame the issue as the appellant seeking the right to chemical gender transition for his patients, but that narrow framing misses the point entirely. The fundamental right that is implicated by the healthcare ban is a right to medical decision-making without undue government interference. Appellant is not saying that the state does not have the ability to regulate the medical profession generally. He is simply asking that the life and health-preserving medical care that he provides his transgender patients be treated and regulated the same as all other health care that he is allowed to provide to young people in North Dakota. And again, because the healthcare ban infringes on a fundamental right and it is subject to strict scrutiny, this court has held that Article 1, Section 1 guarantees both the right to refuse medical treatment and the right to access life and health-preserving medical treatment.
Does your conception of the right necessarily include sort of a right to access experimental cancer drugs, for example?
This is different. These drugs are not experimental. The FDA has a very specific definition about experimental, and there is evidence in the record from former FDA officials that talk about what is actual experimental medicine. These medications are all FDA approved. They have been on the market for decades. Providers know the risk profile.
Are these off-label uses, or are these approved uses by the FDA?
So for the puberty blockers, they are approved for treating central precocious puberty, which is essentially doing the same thing where it's pausing puberty, and they are approved for use on minors. So yes, it is off-label, but the population is the same. And the FDA also, and we have evidence in the record, says once something is approved, physicians can prescribe medication off-label within the standard of care. And North Dakota also encourages off-label prescribing when it's in the standard of care. There is a law that requires health insurance companies to cover off-label treatment. And then, so there is this, and again, it goes back to the history and tradition of North Dakota to having deference to physicians to treat patients and exercise their medical judgment and not have the state second guess that medical judgment.
So your argument seems to me to blur the idea of standard of care and constitutional right under Section 1. Is there a gap between those things, or is everything that's within the standard of care that it affects health and life a constitutional right?
I think it does fall within that because, well, the Constitution undoubtedly covers life and health preserving medical care, and the standard of care part goes into whether it should be the state that regulates the medical profession deciding what the standard of care is, or if it should be the medical profession doing that. And that's what the Constitution protects, is that right to that accessing health and life-preserving care from physicians that is, they're practicing within that standard of care. The healthcare ban also is contrary to North Dakota's history and tradition related to the live and let live ethos that the state had at founding, where autonomy was extended to all, including transgender people who migrated to the upper Midwest around the time of statehood to enjoy independence from repression. They enjoyed freedom of movement and did not have to register with state agencies or have their gender appear on identification documents. Transgender people, just like all other settlers of the Dakota Territory, were measured by their contributions to building up fledgling frontier communities. As long as someone was willing to contribute, they were accepted, even if they were perceived as different. And again, at statehood, there was a huge deference given to the medical profession. Early regulations of the medical profession, which were crafted by North Dakota physicians themselves, included license prerequisites, but they didn't involve second-guessing the reasoned medical judgment of physicians, nor do they involve interfering in the doctor-patient relationship. And there's no historical analog in the state to single out a small population of citizens and deny them access to care without any exceptions for their health.
Where does the historical reference come at statehood that there were transgender people in the state?
So Dr. Baker testified, I can give you a record site, but he testified about the history of North Dakota's founding, the Constitutional Convention, and there was one example of Mrs. Nash, who was a very well-known and respected North Dakotan, who after she had passed away, it came out that she had male anatomy, and that made news, and Dr. Baker testified that given the demographic of those that founded and participated in the Constitutional Convention, they would have known about Mrs. Nash. They would have known about they would have read the newspaper.
So one person.
One really high-profile North Dakotan. And the district court, there's also two main reasons why the district court erred in concluding that this fundamental right to medical decision-making belongs exclusively to persons of adult years. because the North Dakota Constitution explicitly provides all citizens of North Dakota the right to enjoy and defend life and pursue and obtain safety, and minors have that constitutional protection. Minors also have the right to access medical care with their parental consent. And when it comes to medical decision-making, it is the parent and not the government that participates in the informed consent process. Keeping state intervention to the matter of child rearing to a minimum is essential to the American ideal. And the healthcare ban makes it so that the government makes medical decisions for these adolescents instead of well-meaning fathers like Peter Rowe, who testified at trial about his family's experience. Peter testified that he spent almost a decade refusing to accept that his daughter Pamela is transgender. And Pamela testified that once she started going through male puberty at around age 12, she felt hopeless because she knew that these unwanted changes would be permanent. Her symptoms of his distress included anxiety so significant that it was like panic and terror, and she experienced thoughts of suicide, spoke of not wanting to be alive, and engaged in self-harm. Peter first took Pamela to a therapist, hoping that the therapist would help her accept her gender assigned at birth, but therapy alone did not relieve Pamela's significant distress. And over the course of several months, after educating himself on gender dysphoria, having many family discussions where they worked through disagreements together, and after consulting with medical care professionals, Peter decided that for his family, gender-affirming care was not only the right medical decision for Pamela, but a life-saving one. And gender-affirming medication has been a huge benefit to Pamela. Her father, Peter, described the difference between her life before and after gender-affirming medication as being like night and day. Her depression and hopelessness are now gone, and she is excelling in school and making friends. The district court contravened the constitutional framework envisioned by Section 1 by failing to recognize that the ban encroaches on the fundamental rights to personal autonomy and self-determination under Article 1, Section 1 by denying appellant, his patients, and fathers like Peter Rowe the ability to choose life and health-preserving medical care that qualified medical providers have determined in lines with the standard of care and individual patient needs. And the remedy is for this court to remand to the district court to apply strict scrutiny. Turning to appellant's equal protection claim, the district court erred in interpreting sections 20 and 21 of the North Dakota Constitution and applying only rational basis review instead of heightened scrutiny for 3 reasons. First, the plain language of the healthcare ban classifies based on sex. When the wording of a statute is clear and free of all ambiguity, the letter of it is not to be disregarded under the pretext of pursuing its spirit. Here, the healthcare ban facially classifies based on sex, so the court should look no further. The legislative definition of sex is the operating mechanism of the healthcare ban, and similarly situated individuals are treated differently based solely on their sex assigned at birth. And this is exactly the type of sex-based discrimination against the individual that the Equal Protection Clause is intended to protect against. Importantly, to enforce the healthcare ban, the state would have to show, the government would have to establish that the individual patient's sex to a jury beyond a reasonable doubt. The ban also mandates gender conformity and adherence to sex stereotypes, even if doing so threatens the person's life and health. And because the healthcare ban classifies based on sex, the district court erred in not subjecting it to heightened scrutiny.
So how does North Dakota's Equal Protection Clause differ from the U.S. Constitution's Equal Protection Clause?
So the North Dakota Constitution, the Equal Protection Clause is more, the principles of federalism make it so that the federal Equal Protection Clause, when courts interpret that, they have to have more restraint, but state courts do not. And under the Equal Protection Clause, we also have a big difference in that sex-based classifications are under strict scrutiny instead of intermediate, like under the Equal Protection Clause of the federal Constitution. And it just, Yeah, it's more expansive. The North Dakota Constitution is a long-form constitution.
So our Constitution doesn't even use the words equal protection. We sort of infer that, I think, into a couple of differently worded provisions. You seem to object to our use of federal equal protection doctrine in certain respects, but isn't that already grafted onto how this court has interpreted those differently worded provisions?
You are right that they are different. They're differently worded. The North Dakota Constitution has more of a focus on the individual and rights being guaranteed and laws applied equally to everyone. And so under the North Dakota Constitution, the Equal Protection Clause, it does focus more on the individual and how the law treats the individual. And that is important here in terms of when you're looking at these sex-based classifications, how is the individual being treated differently under the law because of their sex? And therefore, strict scrutiny should apply to that law when it does treat them differently.
So you don't find a particular problem with the age or the medical purpose distinctions in the statute, purely the sex distinction?
There is case law that just because there may be some permissible purposes, that doesn't mean that it remedies it from the unconstitutional purposes. And so the North Dakota Supreme Court has treated age it has recognized that at some point minors may not be able to make decisions, but even in cases like child custody, they're talking to the child, they're making that determination, can this individual, express themselves? Are they old enough? And adolescents in North Dakota, there's evidence in the record, are undoubtedly making these decisions informed. They are old enough and they should have the same rights as adults, and they do under the Constitution.
Your time for your opening argument has expired. You can use your rebuttal time if you want to continue on at this time.
That's okay, Your Honor, I can.
Thank you for your argument. Mr. Axt, when you're ready, you may proceed.
Good afternoon, and may it please the court. Phil Axt for the state. I'd like to start by responding to why our law satisfies rational basis and address some of the points why the state has legitimate concerns about subjecting children to these procedures, and then I'll address why it's not subject to heightened review. So on rational basis, it's important to note what this case is not about. It's not about deciding the best way to treat children who are struggling with gender dysphoria. The court doesn't need to answer that question to resolve this case, and in fact, answering that question is probably outside the judicial competence. Now, a lot of what you heard from counsel for plaintiff was their opinion on that question. They said that when a child reports feeling mental distress because they identify as someone with traits of the opposite gender, that the appropriate thing to do, the medically necessary thing to do, is inject that child with powerful, life-altering chemicals. First, chemicals to stunt their normal pubertal development, and then chemicals to make them develop secondary sex characteristics of the other gender. There's no other situation where it's considered appropriate to treat an otherwise healthy child, a physically healthy child, who reports mental distress over their self-perception with some form of clinically diagnosable body dysmorphia by permanently changing their physiology. When an otherwise healthy child reports severe mental distress because they identify as someone who should be thinner, we don't inject that child with Ozempic. And when an otherwise healthy child reports severe mental distress because they identify as someone who should be stronger, we don't inject that child with steroids. But when an otherwise healthy child, a physically healthy child, reports mental distress because they identify as someone who should have traits of the other sex, in that case, plaintiff says the best way to treat that child is to put them on a trajectory that will require a lifelong dependency on pharmaceuticals and can lead to an adult life of sexual dysfunction and infertility, along with many other known health issues, decreased bone density, heart problems, blood clots, many other serious physiological risks. Plaintiff says those risks are acceptable not because they address any physical condition or ailment, but because they'll improve the child's mental well-being. But even that purported mental health benefit is doubtful and debated. State has offered evidence into the record, and the district court found, in this case, that the studies cited to support such claims about mental health benefits are low quality and not reliable. The Cass Review in England spent 4 years surveying all of the available research in this field and found there was, quote, no good evidence that subjecting children to these chemicals improves long-term mental health outcomes. And as to reducing the risk of suicide, the Cass Review found, quote, the evidence does not support this conclusion, end quote. The state also offered evidence into the record for this case that when studies came out and they didn't support plaintiff's preferred narrative, when they urged caution before doing this to kids, those studies were systematically suppressed. Discovery ordered by a court in Alabama revealed that one of the organizations pushing these procedures as being medically necessary and saying they should be performed without any age cutoffs. Internal documents showed those guidelines weren't developed by following the scientific method or seeing what had been demonstrated to result in long-term patient outcomes. Instead, those guidelines were littered with the phrase medical necessity without any supporting data for doing so at the direction of lawyers litigating in this space. The irregularities in that entire process are deeply concerning. In fact, earlier this month, a couple weeks ago, the FTC brought a lawsuit alleging that many of these statements were knowingly false and deceptive when they were made, including a claim that you'll find in plaintiff's briefs, the claim that puberty blockers are somehow fully reversible. That claim is alleged to be knowingly false and deceptive by the FTC. But the court doesn't need to decide who is right on any of that. The court just needs to decide whether the state had a reasonable basis to conclude that injecting a child with these drugs is not an appropriate way or an ethical way to treat a child who reports feeling mental distress from gender dysphoria. And of course, the state has a reasonable basis to conclude that. We don't legally allow children to drink alcohol, even with parental consent. We don't allow them to use tobacco. In many parts of the state, we don't allow children to get tattoos, even with parental permission, because we've long understood that there are some decisions we do not leave to the discretion of an 11-year-old. Because going through puberty can be a challenging time. I suspect it always has been, and I suspect social media hasn't made it any easier, but that doesn't mean the state must, or even that it should, allow children to change their entire life's trajectory by stunting their development and putting them on a path of sexual dysfunction and infertility based on feelings they report as a child, feelings which, for many children, go away as they progress through normal puberty. That's why the U.S. Supreme Court has said Tennessee's law survives rational basis. So has the Supreme Court of Missouri, the Supreme Court of Texas, the Fifth Circuit, the Sixth, the Seventh, the Eighth, the 10th, the 11th. All of those courts have recognized there is fierce disagreement over how to treat children suffering from gender dysphoria, and the state has a legitimate interest protecting them from such life-altering procedures until they've reached an age and maturity to know what it is they're risking and what they're giving up. One other point on rational basis before I move on, it's not just the state of North Dakota that questions subjecting kids to these procedures, nor is it just 20 other states with similar laws. In this case, you also had the benefit of the district court's analysis, who heard 7 days worth of testimony, including from competing experts, and who concluded after hearing that testimony that the evidence establishes there are legitimate and credible concerns, factual concerns, with the narrative that plaintiff is trying to spin here. Those findings of fact, those credibility determinations are reviewed for clear error, as you mentioned, Justice Barr. So plaintiff has a high burden to claim not only is the state wrong, not only are 27 other states and the territory of Puerto Rico wrong, but that the district court's weighing of the evidence in this case was not only wrong, it was clearly wrong. Plaintiff cannot come close to meeting that burden, and North Dakota's law easily passes rational basis. Now, plaintiff offers two arguments for why the court should apply some level of heightened review instead, the fundamental rights argument and an equal protection argument, and I'll address both in turn. Starting with fundamental rights, Article 1, Section 1, the general rights to life, liberty, safety, and happiness. Plaintiff says those words contain a right to inject children with puberty blockers and cross-sex hormones, but they simply don't. As this court has explained, the rights guaranteed by Article 1, Section 1 are the rights known to the people when our Constitution was adopted in 1889, but there's no way to conclude the people of North Dakota in 1889 would have understood our Constitution as creating a right to perform these procedures on children. Such procedures did not even exist until only a few years ago. And it's not like this is a new treatment for an existing practice, like a new medicine for treating cancer. This is an entirely new and unprecedented kind of procedure. They are permanently changing a child's physiology based on a mental health diagnosis for body dysmorphia reported as a child, sometimes as young as 8 years old. There is no historical support for doing anything like that in this state. So plaintiff says you should widen the aperture. He says our state has always recognized a right to receive what they referred to in their briefing as best practice medical procedures, but that's just patently false. Since territorial days, it was illegal to perform abortions unless necessary for preserving the mother's life, regardless of whether a doctor thought it would be best practice for her mental health. And as you alluded to earlier, Justice Tufte, the argument that there's a fundamental right to any procedure a doctor deems best practice just runs headlong into all the cases dealing with experimental medicine. It's well established the state can restrict experimental procedures as part of its authority to regulate the medical profession. Plaintiff hasn't pointed to anything in her history suggesting otherwise, and I think earlier they conceded that the state can regulate experimental procedures, but that's exactly what this claim about a fundamental right to any procedure a doctor deems best practice would boil down to. It would be a constitutional right to experimental procedures, even if the state deems them unsafe or unethical. Nothing in her history or tradition support that either. So plaintiff tries to tie these to life-preserving treatments and say they're protected like the right to life-preserving treatments this court recognized in the abortion context. And he says they're life-preserving not because they will cure any physical ailment, but because kids may commit self-harm if not allowed to undergo them. The court should reject that argument for numerous reasons. For one,
Mr. X, I'm going to interrupt you real quick because you're talking about an area I was going to ask Ms. Pellegrini, but I didn't have the chance to. Throughout her opening argument, she kept using the term life and health preserving. Our 2023 decision in Wrigley only said life preserving, correct? It didn't use such a broad term as health preserving, or am I recalling incorrectly?
my recollection is it did use a broadly defined life or health preserving, but then it later clarified that by life or health preserving, it meant serious life-altering injuries.
Do you have a view on the precedential value of the injunction and the stay opinions in that case, which resolved likely success on the merits versus the final merits decision?
Well, Your Honor, I think the merits decision would generally be accorded higher weight. As Your Honor is aware, it's in a different position here because the controlling opinion for the abortion line of cases is itself a controlling minority opinion. So the precedential value of them may be require a little more analysis, but I think in general, the merits decision would have more precedential weight than the stay or preliminary injunction decisions.
One of the issues we had with those line of cases, at least early on, was the criminal penalties that apply. And you've relied heavily on the, I'm not sure how you pronounce it, the Schmetti case?
Scrimeti?
That case has penalties that do not involve criminal penalties. Can the legislature put a criminal penalty on anything they decide to regulate?
Generally speaking, unless it's prohibited by the Constitution, I would say yes, Your Honor. That's within the legislative prerogative to define criminal law. So to go back to what I was saying, the argument that this is a life or health-preserving procedure should be rejected first on its premise because it's a disputed fact. As I noted before, when I started, there's fierce disagreement with the claim that subjecting children to these procedures will decrease suicide or even improve mental health outcomes in the long term. Again, on the claim they reduce suicide, the Cass Review found, quote, the evidence does not support this conclusion, and studies have found that performing these procedures is actually correlated with decreased mental health outcomes, as the district court noted below. So that makes this case fundamentally different from the abortion context. In that context, there was no dispute about the effect of the procedure. You were ending the life of the child to save the life of the mother. But in this context, there's fierce disagreement over the effect of the procedure itself. And states have wide discretion to pass legislation where there is medical and scientific uncertainty. That's, of course, the U.S. Supreme Court in Gonzalez. Moreover, another thing on that point, even if there wasn't a fierce debate over the effect of these procedures, the claimed injury here is fundamentally different from the right to life or health-preserving care in the abortion context. In that context, we're talking about a direct threat of physical bodily injury, and we've long recognized a right to protect oneself against physical bodily harm. That's the self-defense right, but this court has never extended that right to protecting one's mental health. And in the abortion case, the controlling opinion of Justice Tufte and Justice Jensen expressly rejected the idea that Article 1, Section 1 extends to threats of mental harm. So the court should reject the idea that the people of this state in 1889 would have understood our Constitution to enshrine a fundamental right to inject children with puberty blockers and cross-sex hormones. Nothing in the history and traditions of our state support that idea. Moving on to equal protection, Article 1, Sections 21 and 22. Well, let me pause, unless there are any other questions on fundamental rights before I move on. So on equal protection, similar equal protection challenges, as you noticed, Chief Justice McEvers have been rejected by the U.S. Supreme Court, Missouri Supreme Court, Texas Supreme Court. Plaintiffs hasn't offered any persuasive reason why the analysis would be any different under North Dakota's Constitution. Like those other constitutions, our equal protection provisions don't prohibit legislative line drawing. What they do prohibit is treating similarly situated people differently based on inherently suspect or irrational classifications. Our law doesn't do that. Our law distinguishes on two criteria. First, on age, and second, on medical purpose. Neither of those warrant heightened scrutiny. First, it draws a line based on age, only prohibits these procedures on children under 18. Plaintiff doesn't argue that raises any equal protection concerns, so we can move on from that one. Second, the statute draws a line based on medical purpose. No child of either gender can receive hormone infusions or puberty blockers for the purpose of transitioning their gender appearance, but there's nothing inherently suspect about distinguishing drug use based on medical purpose, allowing drugs to be used for one purpose but not another. For example, the state can allow the use of powerful sedatives to relieve pain or control seizures, but it can prohibit their use when done to facilitate a suicide, or treat high blood sugar, or treat allergies, or for any other purpose that doesn't require the use of strong sedatives. Or, perhaps a better example, human growth hormones. State can allow the use of human growth hormones when done to help a child with pituitary gland issues develop at a rate consistent with their peers, but it can prohibit the use of that drug when done for a child who is otherwise developing normally, when the purpose would be to make them develop faster or bigger than their peers.
Mr. Axe, I hate to interrupt you. I think anyone could talk faster than I can, but I think you've disputed that. The medical purpose, I'm just kind of curious, you mentioned a few minutes ago about what is and the record here, the lower court, is there a dispute among how many states about the medicine, the science of this issue? Is that what we're getting at with the medical purpose? Is there a dispute about what is a legitimate medical purpose?
Yes, Your Honor. I think the dispute ultimately boils down to whether the net benefits outweigh the net risks. And 28 states and the territory of Puerto Rico have made the determination that the risks do not outweigh the benefits of providing these procedures to children.
And is that in the record with the lower court?
Yes, I believe so. I don't have a record site in front of me, but yes. So just to wrap up that point about purpose of a drug-based discrimination, that doesn't violate the Equal Protection Clause. I was using the human growth hormone example, because a child who has pituitary gland issues and a child who does not are not similarly situated for equal protection purposes, at least not when it comes to the purpose for the hormone therapy. Likewise for here, when a child receives hormone infusions to treat an endocrine disorder and a child wants them to treat a mental health concern of gender dysphoria, those children are not similarly situated, at least not with respect to the purpose for the hormone therapy. So plaintiff said our law discriminates based on sex, but that argument is wrong. As I mentioned, under the plain text of the statute, no minor of either gender can be subjected to these procedures for the purpose of changing their gender appearance. The operative text, to use their word, is not sex. It is the purpose of the being provided the treatment. The fact that the application of the law looks different for boys and girls is a function of biology and medical realities. It's not discrimination under the law as that's understood for equal protection purpose, and if plaintiff was right, if this was discrimination based on sex, all sorts of guidelines governing the practice of medicine would suddenly be constitutionally suspect. Because a girl receiving estrogen to feminize their appearance when they have an endocrine disorder, and a boy wanting to receive estrogen to feminize their appearance for a diagnosis of gender dysphoria are not similarly situated. Giving the girl estrogen to correct an endocrine disorder can alleviate future fertility problems. Giving the boy estrogen in response to gender dysphoria can cause future fertility issues. They're fundamentally different procedures, different purposes, different effects, different risk profiles, and pretending like they're not, to quote the U.S. Supreme Court, would be especially inappropriate. To quote that court further, some medical treatments and procedures are uniquely bound up in sex, but that doesn't change the fact the law classifies based on procedure, not sex. Unless there are any questions on equal protection, I'd like to briefly respond about the allegations regarding parental rights and parents being able to provide consent. This claim isn't actually before the court. It was dismissed for lack of standing. Plaintiffs didn't appeal it. I'm also happy to discuss why it's wrong. As I mentioned before, there are many situations where we've long said minors lack the capacity to make certain choices and parents cannot provide legal consent for them to do it. Alcohol, tobacco, tattoos. We have child labor laws. We don't allow children to work in factories. We don't allow children to make pornography, even if their parents thought that would be appropriate. And to bring it back to this case, there's nothing in our history that suggests the right to raise one's child, which we acknowledge is a very important right, means that you can subject them to experimental medical procedures the state considers unproven at best or abusive and unethical at worst. Moreover, plaintiff mentioned informed consent, so let's talk about the informed consent statute. This is Century Code 23-12-13. Plaintiff said it generally allows parents to provide medical consent for their children, and that's generally true, but 2 points in response to that. First, again, nothing says in that statute suggests that parents can consent for their children to undergo otherwise unlawful procedures. Secondly, I would direct the court's attention to subsection 6 of that statute, which expressly says a parent cannot provide informed consent for the sterilization of their child. If someone is going to be sterilized in this state, they need to be old enough to understand what is happening and consent to that themselves, or there needs to be a court order. That is not something a parent can legally provide informed consent for. That's been the law of our state for decades, since at least 1991. So this idea that parents can provide informed medical consent for anything is just factually incorrect.
I want to ask you more of a procedural question about some of the factual determinations made in the trial court. So, to the extent a factual determination bears on original meaning of the state constitution, say the Section 1 argument, we don't review those kinds of findings for clear error, do we? The way I'm sort of answering my own question to some extent, but it seems like the fact determinations that go to a rational basis today for the statute are differently situated than the ones that go to historical meaning. Can you help me with that?
Yes, Your Honor. I think the clear error standard of review would go to the underlying predicate determination, so the credibility determinations. You heard Counsel for Plaintiff saying there's no legitimate dispute about the efficacy of these procedures. The district court concluded otherwise after hearing that evidence. I think that's an underlying predicate determination that would be reviewed under a clear error standard. And now how you apply that determination to the law would be de novo. And unless the court has any further questions, that wraps up my remarks.
Thank you, Mr. Axe, for your argument. Ms. Pellegrini, you have 5 minutes left for rebuttal. You can put that podium down if it's a little too high for you.
Thank you. I'm a little shorter than my friend on the other side. I just want to start by clarifying a couple of points that were raised by my friend on the other side. The first one is that he mentioned a lot of other states and facts from other cases, but the healthcare bans in other states are not part of this record, neither are the facts from those cases. What is part of this record is undisputed testimony that all of the providers who provide gender-affirming care in North Dakota are pediatric specialists who routinely provide all forms of medical care to minors. They follow North Dakota law concerning consent from parents and guardians, assent from minors, and they ensure all families have all the information they need to move forward. All parents and minors testified that they were well informed, they were encouraged to take their time and think things through, and that their experience with gender-affirming medication was entirely consistent with the information provided by their physicians. Another thing that my friend on the other side raised was about the abortion case, and Your Honor had asked if there was how much precedential value that one has. I also wanted to mention that the Vogel case also holds that there is this right to life and health care as well, so it's not limited to that. And unless your honors have any other
I
questions.
have one. I know you have limited time, but it sounds like you're about done anyway. I believe it was a state, but maybe it was an amici who tried to compare this situation with anorexia nervosa. And we don't use drugs, off-label or otherwise, to address anorexia nervosa. It's through counseling, as I understand it. And so why is that argument not persuasive?
They're different medical conditions. I am not as familiar with medical treatment for anorexia nervosa, so I can't speak to what types of medical treatments that the medical community has said work there. But here, the evidence at trial was that this care, as it was provided in North Dakota, is life and health preserving for some individuals with this condition, and that is also based on the medical consensus at large in the United States. And because the state is banning access to life and health preserving care, that is what triggers a fundamental right and triggers strict scrutiny. And with anorexia nervosa, I'm not sure the same would apply there, but I'm not as familiar with the medicine, so I can't speak to that. Sorry, Your Honor.
One follow-up question on the different types of factual determinations. You talked about a Mrs. Nash back from the statehood era. If there were findings by the district court about what happened related to that individual, would those be findings we would review for clear error as they go to the original meaning of the Section 1, or are those in a different category for an appellate court's review?
I believe that they would be relevant to the review. I don't believe that was what the district court based its holding on. It was more of there was this testimony, and so I do think that this court could consider those facts as well as sort of going to, at the time of statehood and the North Dakota Constitution, who were prominent figures, including a transgender woman, Mrs. Nash, and how she was treated and respected, and how that reflects on the culture and tradition in North Dakota at that time. Any other questions? If not, I yield the remainder of my time.
All right. Thank you, Ms. Pellegrini, for your argument this afternoon, and Mr. Axe, yours as well. This case will be taken under advisement, as all cases are, and this court will be adjourned until 9:30 a.m. on Tuesday,